don't win, that's $20,000 that's gone. Okay? Cases cost between $15,000 and $50,000 or more. I don't think I've ever spent $50,000. I'm conservative, but $25,000 to $35,000 is not unusual for a botched circumcision case. If they can't be, and when I advance expenses, the IRS will not allow me to deduct them as ordinary business expenses because I expect to recover them back, so I have to book them as client loans. If I get them back, if I do, then they are not taxable too. But basically the lawyer has to eat the costs. Contingency fees therefore have to be high, 40 to 50% plus expenses. And generally, if I'm allowed to in a state, I charge 50% plus expenses because of this risk. However, many states limit my fees. And it's interesting which ones do. The so-called liberal states do. New York, Massachusetts, and California limit the fees. Here in California, you have to deduct the expenses first before you calculate the fee, which is just unbelievable. And that makes it hard to bring cases. That's why probably you're looking at it when it comes to people who do this sort of work regularly, in penis cases. The defense has unlimited funds and will expend the same. Their fees are not limited by law, but only by the market. The defense lawyers have every incentive to bill. They send pointless interrogatories, the ones which are questions we have to answer under oath. Many of them they know are overly broad, so they know I'm going to waste time objecting to them, but I have to, because if I don't object, then I have to answer them. I just did a deposition that took about 45 minutes on direct. This is on Tuesday, of one of my experts for trial. They did a 2.5-hour cross-examination going to everything imaginable. And they never settle without doing depositions, no matter how clear the case is. That's simple. Lawyers have to pay rent, salaries, overhead, and eat. We spend much of our time answering questions for free, particularly in this area. Basically, myself as well as other lawyers can only afford to take cases that we think we can win. We can't bring lawsuits that are pushing the envelope unless we are paid by somebody. I can go into this in more detail, but I just hit on it. Class actions, claims that parents can't consent, equal protection are all nice theories. But when you get right down to it, if I go too far, there's a little thing called Rule 11 in the federal courts, and most state courts have it. They say if you bring a frivolous case, which of course is in the eyes of the beholder, you get to pay the other side's attorney's fees and costs. And when people want me to sue bravely, then they're going to have to come up with a brave amount of money so that I can pay $500 an hour or more to the defense firm, okay, if they get me on Rule 11 sanctions. And frankly, I'm just too old to take a $100,000 risk of having to pay out of my pocket to somebody else. So bringing brave cases takes money. Lawyers also don't make the law. We only enforce it or argue for its advancement. We, like the courts, are constrained by prior decisions. For example, it would be impossible to even touch on the 14th Amendment. But basically, if you're going to enforce the 14th Amendment, you have to sue a state actor under what's called 42 U.S.C. 1983. Okay, and they have qualified immunity, which means if there isn't a case that says it was wrong, then how would they know it was unconstitutional? Okay, and so they get a free bite at the apple. I'm serious, folks. I didn't make this up. All right? I'll give you an example. Foster parents in Georgia, okay, beat a child or cause a child's death by beating it. Because they are State Tort Claims Act says they're state actors, we can't sue them for battery. Okay, so you can't sue them there. The 11th Circuit held, well, parenting is not an exclusive state action. Therefore, they are not state actors for the purposes of 14 U.S.C. 1983. Right now in Georgia, there is no remedy except the criminal law for a foster child who's beaten even to death by a foster parent. Okay? Courts generally follow society. The courts rarely lead society. It's already been talked about, and it's just a truism. The courts are constrained by the Constitution. Many judges are elected and therefore have to be responsible to the electorate. They bring their own baggage about what's normal in their own religion. They attacks upon what I call the paradigm and the ancient are met with skepticism. That's why everybody thought that 1996, I talked about this, there is no magic bullet in the law that's going to end circumcision. It just isn't going to happen. The First Amendment, I believe, is a real stumbling block to outlawing circumcision in this country. Whether we like it or not, I think it is there. And even if it weren't, all we have to do is look at what's happened in San Francisco, here in California, Germany, and Iceland to see how difficult really outlawing circumcision is going to be. It may happen, but I don't think it's going to be soon. So how can we use the law effectively? Well, I think we bring suits that have a good chance of being won. We bring enough of them to get attention of the doctors, hospitals, insurers, and parents. And if another solid case will let you push the envelope, I'm all for it. In the Stowell case, where a young man came to me at 18 and was angry that he was circumcised, we find that his mother did not want to consent, had signed a consent form but didn't remember doing it because she was on Demerol. She was given Demerol at 4:30 in the morning and she signed at 7:30 in the morning, had no idea she'd signed it, and was surprised when she got him home. So we actually sued, and I raised everything in that case, and we were able to settle it. I don't know what would have happened if we'd actually gone further. We had a very good judge who set aside his religion and followed everything right in accordance with the law. Federal judge in Long Island is absolutely excellent. All right, but each suit at least educates the doctors and the defense lawyers. That's one reason I'm willing to do this. I know that when I go in and I go through all the stuff we do here, about the anatomy and the function, that the lawyers may laugh at me, oh, you're an idiot. But you know what? They think about it, okay? And then they talk to people. And the defendants talk to people. The first case, the Maryland got me involved in this in 1995. The doctor, who was a wrongful circumcision case in Montgomery, Alabama, the doctor after the case said, I didn't do any of this, and I'll reconsider. I don't know if he stopped doing it, but at least he thought about it, okay? So each suit proves the dangers and the damage caused by circumcision. All right? Consider where we were in 1971. Here's an article. It's on CIRP. You can find it. Here was the opinion of a lawyer for the AMA. A lawsuit arising from a circumcision is extremely unlikely statistically. Such a simple procedure is, of course, not likely to produce great complications. The usual requirements of standards of skill and care and knowledge, however, do apply to this as to any other surgery. Well, unlikely, there's a class development injury for the internet on the left. That's a gonco injury in the child that I represented on the right. Not unusual. Here's a Mohgen ablation with the glands reapproximated, and the jury didn't think that was worth much. And here's one where that chunk was removed that had already been discarded, okay, and I did get a significant recovery and settlement for that child, okay. This lawyer went on. It should be noted, however, that if parents of a newborn baby do not want him circumcised, make this fact known to the obstetrician or hospital, and the procedure is carried out by mistake or failure to read the patient's records, a suit for assault and on behalf of the baby may well succeed. Damages, however, would be comparatively minimal unless the parents could prove negligence in the manner in which the procedure is carried out. Disagree with that. All right? I'm going to get to it in a minute. In a few states, which have very liberal decisions allowing damages for mental anguish, it is at least possible that parents will also have a cause of action for mental anguish, although no decisions on the subject can be found in those states. Care, therefore, should be taken to note the mother's hospital records that she is not, in fact, consented to the procedure. Well, the way I got involved in this was a wrongful circumcision case, which is, I've done a number of them. Preventing circumcisions, botched infants, botched adults, and forced retraction cases, which are the type of cases I've handled over the years. Wrongful circumcisions. Maryland got me involved in the cases how I got started in all this in 1995 with Jim Snyder down in Hugh V. Smith Jr. at the Law Center in Montgomery, Alabama. And we tried that case and got a $65,000 verdict, which was a record at that time. Okay, and I was nervous as hell, I'll tell you, because I wanted to win and prove it. I probably overproved the case, but we prevailed. Interestingly enough, that started to produce other cases, but the next case I didn't have as good a judge. And even though the defense really cheated in that case, we had a defense verdict, but I'd settled with the hospital before. And then the other one that I've tried was in Indiana, where in Muncie, where they argued this is what we do to our children in this community. And even though in Indiana you have to go to a medical board, and they could bring the medical board in, this guy came and said, well, it was wrong, there's no harm done at all. Jury bought it, 0, okay? But settlements, I've had about 20 since 1999, with a general range in the middle 5 figures, which certainly hasn't made me rich, but it's kept me in business. My next to the last case was in Georgia, and it was settled in 2011, with circumcision in 2009. And look at all the states where I had them, all across the country. It appears that most hospitals are now using timeouts before doing circumcisions. I don't know if the Joint Commission requires it now, but it didn't used to be the fact, but they are. And I hope my suits had something to do with it.
What is it?
What's a timeout?
Oh, a timeout is that the nurse says, I've looked at the chart, and they get the doctor together, and they say, look, we've got a permission slip. and we check the number on the permission slip with the number on the baby, and we know this is a circumcision. Both the doctor and the nurse agree. Okay, it's called a timeout. And they do it before all sorts of medical procedures to make sure they don't cut off the wrong leg or operate on the wrong eye. Like they didn't used to do them in circumcision cases. They do now. But I have a case. The most recent case just arose in Georgia where parents didn't want it done. They still have the original consent form because it was never collected. Doctor did it anyway, and the nurse certified him a timeout in the record. And that one I hope I will get settled. But it is the first one since 2011 to come into my office. So I think that means that I hope that what I've done has had some good effect and has at least kept babies intact whom the parents wanted to remain intact. Okay? That's the good news. Now, preventing circumcisions. These don't usually get in the news. Some of them have been. I worked on 3 that came to sort of satisfactory resolutions. Okay, I had hearings in 3 and really in a 4th where it was a change of custody and the mother was worried that the father wanted to circumcise the children. In Nevada, after the hearing, it settled to everybody's satisfaction, which is all I can say about it, but you can draw what you will from that. In Pennsylvania, interestingly enough, I lost. It was a very disappointing case. In Illinois, however, in this case, and I can use that name because that's a public name, we had 2 hearings, and the Judge Kaplan there looked and said, well, the boy can decide when he's 18, okay? And he did a really good job. He really listened to the evidence. And so, those can be done. But let me say, in parental dispute cases, you can win, but you've got to present clear and convincing evidence. You've got to set the case up correctly from the beginning. You've got to have good expert witnesses who know what they're talking about function, risks, lack of necessity. The lawyer needs to know the anatomy, the functions of the foreskin, etc. And the lawyer has to believe in the case. And I think the cases that have not been successful, and many of you know which ones I'm talking about, things weren't set up right from the beginning, and the lawyer didn't know enough to be able to cross-examine somebody like Dr. Charles Clack, and I wish I'd been able to cross-examine him because I know what he's seen. By this point, I'm getting to know every urologist in the country. Okay, because Flack, who in the case that many of you know what I'm talking about, testified, well, I wouldn't do it, but if they wanted to, I'd do it. Okay? Flack had already treated one of my clients who'd lost most of his gland's penis in a circumcision. Okay? He should have known better. Okay? I don't mind saying it because that's how I feel about it. And he put himself in the public eye by testifying. Okay? But the point is that you've got to be able to cross-examine and know what you're doing. Okay? Botched infant circumcisions, I've had a number. I've had 4 trials of them. We got a very large verdict for a loss of about 1/3 of the glands, maybe 3/4 of the glands in Georgia in 2009. But the hospital walked because the nurse who walked around all night going, I think we cut it off, never got a urologist in, but tried to get a pediatrician to come in who wouldn't come in. The pediatrician got nailed, but the nurse was nice. She tried, the jury let her off. Point is, juries like nice people. Okay? And they don't do what you would think they would do if people are nice. The one I just showed you where there was a reattachment with a Mogan jury, they had a very good jury for the defense. The defense lawyer just admitted it to me, and I only got a $30,000 verdict. But we had entered into what's called a high-low agreement. No matter what happens, you'll get X, but you won't take more than Y, even if you get more. Okay, so that sort of salvaged that case. In South Carolina in 2014, myself and another lawyer got $215,000 for a shaft stripping case, Gomco. But in Massachusetts in 2015, our expert sort of collapsed. The judge didn't like me. I think a little bit of you're a Southerner and I don't like Southerners sort of thing seriously. I believe, even though my grandparents are buried in the same county where I tried the case. It was bad defense verdict. Hearings. I got a default judgment for over $10 million against Mogan Circumcision Instruments Limited. Wow. That's nice. I have a plaque on my wall. I've never recovered a penny. They're out of business. They've been administratively dissolved. We can't find a penny. So there was a lot of work. That was given to us by Jack Weinstein, 96 years old, oldest federal judge still on the bench. He was outraged because, and the reason is, of course, Mogan in his literature said can't happen. No damage to glands possible. Okay? But they'll just tell you, you get a big verdict, and so what? I mean, a big judgment, and so what? They went into default. The second time they never answered complaints. They just ignored everything. They're a small family firm. The Mogan clamp today is manufactured by, the patent's expired, anybody can make one. You can go on the internet and about 10 companies have it. Go look at Alabama, there's hundreds of them, okay? Now settlements for adults, for children, I've had about 22 since 2002. 12 Gonco, 4 Mogan, 2 Plastabel, 1 a Jewish shield, 1 a bone biter. Actually, that was, somebody put up that picture earlier today, a thing that's their terrible way to do circumcision, and 1 with no shield of protection, and that was a religious circumcision. However, I had 2 that I had to dismiss, and 1 my experts sort of failed me, and in 1 the treating doctor actually destroyed the case intentionally. One of a well-known doctor. Well, many things can happen. I can't say what went on, and that was just about the end of that case. It was a shaft stripping case some time ago. Pending, I have 2 in Florida. They're pending or about to get filed. 2 in Florida, 2 in Georgia, 1 in Louisiana, Massachusetts, Maryland, Missouri, and New Jersey. All but 1 are Gonco. 1 involves lack of consent plus negligent operating, and 1 involves the loss of the entire gland's necrosis. Very bad case. All devices are dangerous and have real risk. These are the lessons. Gonco seems to cause more problems, mostly shaft stripping. Mogan seems to cause the most devastating injuries, loss of all or part of the glands, and the Plastabel can slip under the glands and gouge it. Here are examples. Gonco shaft stripping. This child was repaired really well by, I'll put in a plug for him, a guy named William Strand, who's in Plano right outside of Dallas, is a fabulous surgeon, was able to take that remnant and spread it around the glands, and even though we got a good result for the boy, he has had a good surgical result. The one on the right is the child from South Carolina, and shows, but the consistency of everything is quite different when you strip the shaft. The Plastabel gouging, because I didn't have permission of the client, I didn't put up the one that I did. This is one from Tim's website. But that's what it looks like when the bell slips down onto the glands and isn't taken out in a timely manner. And then on the right is a Mogan gland ablation of a child. You can see this almost with that stuff. All right. Botched adult, so much more. These things don't happen very often. Botched adult circumcisions, they seem to be legion. It happens mostly to heavy men like me. I have to be very careful about letting a doctor near me with a knife. In California in 2003, they will re-circumcise a heavy guy because they don't understand that the reason he's got loose skin is because the skin of the penis is loose, the pubic fat as it accumulates pushes everything forward, and he doesn't need to be re-circumcised, but they do it anyway. And in California, we managed to get just over, Charles Bonner and I got over a $500,000 arbitration award for a man in his life. In South Carolina, we tried one where we thought we'd won. It was really funny. It ended up 11-1 for the defense on a Friday night at 6 o'clock. And I moved for a mistrial. And the defense said, "Oh, no, Judge, send it back. They can do it. They can do it." Went back. Half hour later, came back for the plaintiff. There was one holdout said, "I ain't leaving until I award some money. They all want to go eat dinner." All right? But they only gave us a $30,000 verdict. I think my expenses were $24,000. We let the clients keep the rest, and my thanks for that case was a nasty letter from the wife of why I didn't split costs with her. Okay? In Georgia, for a young man, myself and another lawyer got a $1.8 million verdict, which is a shaft stripping with bringing the scrotum forward and creating a penile scrotal web. Very good plaintiff. That's why that one worked out. However, in Alabama in 2017, there was a defense verdict for an older man. Race may have been an issue there in a small town, and the judge was great. In Pennsylvania, a couple months ago, we scared them into giving us a high-low while the jury was out, which was lucky because they came back a defense verdict. We found out at the end it was, you have to have a 10-2 verdict out of 12. And it was 8 for us, 3 undecided, 1 against. And then when they brought it back on Friday, and it got to be 1 o'clock, all at once it was a defense verdict. But we did recover some money from not what he deserved. So and then also I've had settlements in Florida, Georgia, Mississippi, and Washington. I did have a case I talked about at another seminar where, I just got 1 minute. All right, let's go through the lessons. Here are the examples of damage before and after. This is before and after, same guy. Okay, see what happens. This is the same guy, penile scrotal webbing. Very, very common because they don't. And there's a repair of a guy who's not heavy, but that's what he ended up with. And this is a good repair by a surgeon in Georgia who's fabulous. Why? Because this shows the action of the dartos fascia. That's why knowing anatomy really matters. If you don't know the name, at least you know how it works. On the left, the first line is at the glans, all right? And if you stretch it back, though, it's at the base. So if you're cutting, what you do is you go, I'm going to take off all this and take that like that, and you've taken off all the shaft skin. And then the skin you've got left, you think it's shaft skin, but it's not. It's really scrotal skin, abdominal skin. And that's how all those accidents happen. You can see here the mechanism of injury. And then I got forced retraction cases. I have no time to do this, but I have done a few, okay? They aren't worth a lot of money, but the one I got going right now, the Parks case, I put out a press release on it. I thought it was so important because this hospital, Children's Healthcare of Atlanta, has a policy apparently of washing under the foreskins of all boys, which is wrong, okay? And they tore the foreskin back of my client. Their defense is it didn't happen. Parents wouldn't know. This is what the lawyer told me. Parents wouldn't know. These are medical professionals. I said, okay. All right. So that one I'm going to go forward with. If I have to try it, I will, to make a point. I'm determined to end it, but because they aren't worth a whole lot of money, it's almost impossible for me to go to other states unless a parent has money to pay me to do it. Okay. This is about normal foreskin development. We've already touched on that. Then I've got these other pending cases, not to brag, but a lot of them. Okay. And here's progressive retractability. We've already touched on that today. It is age 10 and a half. Born out of my own family. Everybody's different. I know kids who were retractable at 4, then 10 and a half, still partially adherent. All normal. Okay. Success. Number of botches does appear to be decreasing. 2 suits. However, I have 2 suits against the same doctor who didn't perform after the first one. Okay, and I've got a pending suit against that doctor's expert witness who ignored the warnings that I gave her in the first case. Okay? Only the worst cases get publicity, but recovery is important, and that's why I do this stuff. Okay? Lessons. Infants are easier than adults. Parents have to be likable. Parents can't be greedy. Severity of injury matters. Same thing with adults. I think weight, one of those matters. The juries don't like fat people, frankly. Age matters. Employment status matters, etc., etc. Okay? Makeup of juries matter. Oh, I do want to touch on one thing. Never, ever, ever destroy any medical record of your possession without making sure your lawyer has a copy, because if you do, it will be considered spoliation. And as John Geishaker and I learned to our sadness in the case, it can be fatal. Okay? And stay off of social media. What you say on social media is there forever. Mm-hmm. Good for all of us. Be careful what you say, because you're going to have to eat it and live with it. And I think about that every time I comment. Okay? Praying for a verdict, by the way, doesn't work. Everybody's praying for one. Finds out that Jesus takes that money, which is nothing. Now, you think they studied enough to know that, but forget it. Okay? Why do I keep doing this? Thanks to Brother Kay, we have these pictures of post-circumcision babies. If you look at those faces,
that's funny.
Right there, right there. All right. This is why I'm willing to keep on doing this stuff. Okay, for these kids.
Break up the adhesions between the foreskin and the head of the penis.
Pediatrics, the reason we're circumcising is mainly because you feel more comfortable with a circumcised penis, especially since your other 2 children are already circumcised, right? Basically what we're doing is an elective procedure, primarily because you just feel more comfortable. In the clamp, then we clamp it.
medicalization behind circumcisions. Hospitals and doctors can make big bucks off the procedure, especially since the foreskin doesn't always go out with the biohazard. Sometimes it's sold for a profit.
Look at the data. It looks like there are some things that it does reduce the incidence of, but there are things that are incredibly rare anyway.
There are religious, ethical, cultural, and medical reasons to circumcise. For Father Kobe Johnson, despite being circumcised himself, he decided not to circumcise his 4 boys.
The concern of, I'm going to look different than my dad, or I'm going to look different than the other guys in the middle school shower, it doesn't really come up that much.
To him, medical benefits didn't outweigh the risks.